This Guy's Garage. Like and subscribe.
So we like to think that our constitution, our rights and liberty and freedoms are part of our life. In the world we live in, we have those elements, but we live in four dimensions, and this fourth dimension is the time. What we have today are our assets, but time goes on and circumstances change. In 1930, who would have thought that 10 years later, millions of Jewish people would have been exterminated just because they were Jewish people? So in 1940, who would have thought in 10 years later, millions of Japanese would have seen their properties confiscated. In 1960, would have seen hundreds of our citizens would have be sent to prison without due process, just because you think that we live in peace. Doesn't There's no basic guarantee that it will continue. And I quote again now. With that in mind, what is the most extreme example? Let's suppose in 30 years from now, there is another emergency. The government will state, so there will be arbitrary arrestations. The privacy will be at stake. When you think extreme, think about radical. So what are the rights and freedom of Canadian? Do you want the judges decide on the issue? Do you want to decide to write the charter? Do you want the judge this is what will the judge decide on those circumstances? What will be the approach that will see? So what about the obedience of citizens in a fear context? The answer is so. Donc we have principles that exist for decades and centuries. We see decisions so that's the end of quote. And Judges Conference of Judge Strata in 2016. So are you so we are here 8 years later before you. So as the Judge Strada indicates, I appreciate the apocalyptical scenario. Let me suggest to you an utopic scenario.
Imagine a time where there's a pandemic regarding flu. Imagine that we receive that there's a medication for it and we have to get it 4-6 times. But imagine that it has secondary effects and that it creates two classes of citizens, vaccinated and non-vaccinated. That the government imposes this vaccine, otherwise those unvaccinated will be removed away. They won't be able to go to the gym. They won't be able to go in malls. Up to now, it's not that bad. But let's go further. What about if non-vaccinated people could not work and they could not get any gift of organs? They would be treated like dogs. Still in that scenario, hypothetical scenario, let's say they oppose against those measures and that the government and that they decide to protest in the streets and that the government goes against them with the martial law and that they describe them as people who are disturbing. Now, the Prime Minister would ask, how can we tolerate such people in the citizens, that people who participated in these protests will have their accounts frozen, and people who will be fed up of being closed in their homes, and that in the first time in their lives, they will, because of those measures, will decide to go out of their country. They won't be able to do it, even though they have a negative test. They will have to stay against their will in Canada. And if they decide to go against these decisions, they go to court. Many months after that, after the government will decide to give them back their rights without any explanation. It's as if the situation could come back and that we could declare that the whole judicial event, because suspension would mean something else. And with that scenario in mind, I'll ask you a question. Are we totally in a democracy in Canada? Are we really in a separation of power, or are we in a sanitary fascism? Are we does the rule of law prevail? Or I asked about I answered the question about Jude Stratus. I would like the judges to use what has been used for decades now, and that they not be surfing on mootness, and they need to look at the roots of history. The primary right to get out of a country, including yours, it's democratic. It is not tolerable to rape it during a year and then try to make it legal. So if the question you will ask is, how far can a government go to as far as raping somebody with regarding their rights, and then give it back at midnight minus 1 minute? Is it if we make them nationless, do we have a pretension? So why do we prevent them from their rights of circulation and then give it back and make it moot? Where's the difference? The mootness is limited. It is practical in basic situations, but it was used against judicial philosophy. Mootness is very practical. I would like to use that as the government does, but I need to plead a sentence tomorrow in Montreal. One of my clients said that he was guilty regarding a case, but why do we try to find the best sentence for my client? Why are we trying to have a process in Nuremberg? The war was over. It was moot. But I remind you that that process gave birth to the Declaration of Human Rights. We are not judging crimes of war. You are going a little far. I understand. I'm going to talk, if you want, Mr. Judge. I'm not talking about war crimes. So why are we talking about First Nations cases? That's over. But on this subject, the government will never go on the path of mootness. Do you know why? Because the decision makers of before are not those from today. So some will self-inflict wounds, will have self-inflict wounds, but they will have no answer. Justice cannot work like that. In a philosophical way, this is where we analyze, and we not the what kind of society do we have where the government could always defend themselves and not the citizens. This situation where the government could cancel rules that they inflicted at midnight minus 1. It looks like authoritarian governments. Cities where citizens cannot have their rights. We know that it does it when to fight against such government. So that encourages crime. And I'm going to give you an example. In 2022, I was approached by people, and I was offered the opportunity to be given a fake vaccinal passport. I know people who did it, but I refused. Number one, because I never wanted to have something fake on me, because I didn't want to have any vaccinal passport, but I wanted to have my rights that I'm faithful to and that are part of my values. But if this recourse goes goes beyond any ruling, do you think that I will spend thousands of dollars against my defense, and that I will put my life on hold? I will tell you that at the first occasion in such situations, I will take a fake document, not because I'm fraudulent, but because my institutions in my country will have given up, and I know that it will be the only way to have my rights taken into account. And that's what I want that the court understands, the consequences of potential inaction. These are the sacrifices of not doing anything. The results of towards a public that is well informed. That is where the public interest is. The public interest is for to hear the case has made it that we had to put the case online. The judge asked my colleague, I don't want to paraphrase it, but what I understood is that there's a public interest, but of which exactly? So your question reminded me of Pastor Miller, of a survival of the Shoah. When they came to get the communist, I didn't say anything. When they came to get the socialist, I didn't say anything. When they came to get the syndicalist, I didn't say anything. When they came to get me, there was nobody to defend me. So in truth, it might be that yes, the public interest might be aiming at one type of people, but those who are interested in this question are also making a mistake, because it should be based on what measures were taken in place and not who was concerned by it. The question that was raised by what you said was, who will be the non-vaccinated of tomorrow? Have they paid attention to what happened today? Understand that I have no reason to be in front of you today, no reason to have closed my law practice for a whole month. The only reason I did it was by necessity, because I was fed up of living in dissonance, cognitive dissonance, that made me live in the tribunals whereas I couldn't have my rights taken into account. I had no reason to come to Ottawa. The last time I came was in 2022, and there was a big party. But if you think that wasn't welcomed, so when the revolt takes the judicial route, it's impossible that you can't hear it. According to Judge Strachas, but a theme that we talk about abundantly, it's the passive movement, and the lack of action by the courts of Canada, that are making it a subject of mockery. But it's worse that won't be analyzed by a tribunal. We saw that we have a constitution that is not solid. The worst regions in the world have constitutions that are not strong. The constitution doesn't serve any purpose when it is not used. In my memoir, I named it the Procureur of Canada. I do not want to spend that too much, but I suggest that you read it. It raises as it raises a concern that the respondent represents the government of Canada. In the doctrine of Madame Elizabeth Sanderson's duties and challenges of Canadian lawyers, we are indicated that the general procureur is a central person who has to sit to the prime the of the law, and he has to analyze every disposition in accordance with the rights for liberty. It is not to you, Mr. the Judge and Miss Judge, to being Procureur General is not to be ready to go against the government or to accept whatever lobby will choose to do. It's to be independent from the crown and to intervene when things go too far. I know I was to tell you that we had the most discriminatory context in our history. To prevent millions of citizens to leave the country is non-tragic, but it's a policy that is so embedded in bad and that it will be a crime to just brush it under the rug. So I would like the court to hear this case. I was told that I was not able I was told that I was a danger to the air in a plane. So that is a violent declaration I had to endure. I was forbidden to go in an airport. They could not be in an airport. They didn't have a hard time to share a courtroom with me. They had no problem in to shake my hand in a pandemic context to shake my hand, but that is just a posture. This case went very far. It's by the decision of the federal court that people can be educated about civil rights and bring adjustments. It is your responsibility by giving them judgments that are confirming or infirming their positions, and so they might understand that what they are standing for will not be limited to putting pronouns in their signatures. I have treated cases of proxenetism, of sexual harassment, traffic of drugs, anything you can imagine, but nowhere this disgusted me as this one, and I'm weighing my words to declare that millions of citizens did not belong to the society. That is what Anna Arendt called the banality of evil. And I've had, but that is not. I'm someone who loves debates, but in the paramount of rights of law, in nowhere in my career I was told that your client shouldn't be considered innocent at first, or should have no right to have a lawyer. Your client should be detained without any freedom. For the first time here, I heard from the government exceptionally that should not be free to circulate in society. They have removed every right. They have promoted the hatred of the other. They had the occasion of doing something great, something that happens once in a career. They decided to lie down. And I would like to conclude that they would find me on their path every time they choose to defend the undefendable, and every time that the threat of violence is hanging over me. And unfortunately, there's no vaccine against totalitarianism. this is, but this is the portrait I wanted to show you, and on my analysis on many themes on why I believe that as magistrates of the court, you have the responsibility to seize this case. Everything is submitted to you with respect, and I am waiting for the follow up on this. Thank you. Thank you.
So I believe before we hear the respondents, we're gonna take the morning break, 15 minutes.
Order. Hello.
The court is now resumed.
La cour est en session. J'allais dire bonjour, mais
First of all, by being absolutely clear about the issue before the court.
vérifier la situation concernant la cour.
This is an appeal of a decision by the federal court not to exercise its discretion to hear a case that is moot. This is not an appeal of a decision that dealt with the case on its merits. And friends have put before the court several cases dealing with that. Reference was made to recent British Columbia Court of Appeal decisions dealing with appeals from decisions on the merits. We don't have those decisions, say. But in any event, I submit they're not apropos of the issue before the court. Nor is this an appeal, nor do we argue in this appeal that this appeal.
Can I just, oh, sorry.
Oh, this mic here? Here now. No. Needs to be off. All right. Makes perfect sense to me. So you can hear me now? All right. Thank you. To be clear, nor do we argue in this case that this appeal is moot. The sole issue is whether the motions judge erred in finding that the application was moot and in declining to exercise her jurisdiction to hear it. The test for assessing the work of the applications judge was established by the Supreme Court of Canada in House v. Nicola and applied by this court in Majoub, Imperial Manufacturing, and Plato. In particular, in Plato, which is, by the way, we have a compendium which we have provided the court, a 2-volume compendium electronically.
Oh.
And I have at tab 20 of that compendium is the Plato case, a decision of this court from 2015. And I want to be absolutely clear about what we say is the standard of review.
Can I just, I think I've got it as 2 separate volumes. So
2 volumes, that's right.
2.
And it's tab 20 in the second volume.
I'm with you.
Thank you. Paragraph 4, the court says, the identification of the legal factors to determine if a case is moot is a question of law, reviewable under the standard of correctness. Once it is established that a case is moot, the judge has broad discretion to hear the matter or not, but must properly weigh the criteria established in Borowski. This fine exercise of balancing is a mixed question of fact and law. Deference is owed to that decision. So I say, contrary to what my friend Ms. Pejovic argues, the standard of correctness would apply to a question of law or an extricable question of law. The only question that I can see is what is the test for mootness and what are the discretionary factors from Borowski. Everything else in the decision is the application of that test, and the standard applicable to your review of that is culpable and overriding error. In the absence of such errors, and I say there were none in this case, this court ought not to intervene. In Plato, the court says this is a fine balance to which deference is owed, and it is not the job of this court to rebalance the Borowski factors, absent errors of the sort I have discussed. Nor is it the function of this court to make law for the future. And in that regard, I'll ask you to turn up, please, tab 26. This is the QP case versus Air Canada, a decision of this court from 2021, Justice Stratus. And I'm referring to paragraph 13 on page 5, where Justice Stratus says, as for the third consideration, gratuitously interpreting the former wording of the provision in issue, in a case with no practical consequences, just to create a legal precedent would be a form of lawmaking for the sake of lawmaking. That is not our proper role. And I say with respect, that is what the appellants are asking you to do in this case, is to step outside the proper, asking the federal court to do, and now you, step outside the court's proper role to create legal precedent, to provide guidance for future cases. That is not the function of this court. We've heard a lot of speculation this morning, again, I say respectfully, with respect to what might happen in the future. I heard Mr. Ben Nayoum speculate about, get this right, he talked about imagining this or imagining that there are two classes of citizens. And then Ms. Pejovic says, well, the government threatened to bring back these measures. The government said, if you examine that statement, is if circumstances change, it may be necessary to re-implement measures of some sort in response to those changing circumstances. However, the authorities are very clear in my submission that the court does not engage in speculation or passing judgment on speculation. We can only look at what happened. And what happened was these measures were repealed. The orders made under the Aeronautics Act and the orders made under the Railway Safety Act ceased to have effect as of June 20th, 2022. Under the Interpretation Act, and this is in our materials, Section 2, a regulation which has expired is considered repealed. And to be absolutely clear, subsection 2.1 says regulation includes an order. All of them cease to have effect on June 20th, 2022. They are not in force. They do not affect the rights of the appellants in any way, and the judge so found. So on the question of speculation, we have to look at what the courts have said. I'd like to begin briefly with the Phillips case from the Supreme Court of Canada, which is in the compendium of tab 33. And you don't need to turn these all up. I can read briefly from the important portions. But the court talked about the policy of restraint. And this is Judge Sapinka, which, if I'm not mistaken, is the same judge who was deciding Borowski. And Justice Sapinka says at the top of page 113, As the present appeal is not a reference, this court should not, I think, be called upon to answer questions which are not essential to the determination of the case. He cites the Skipinker case. He says the court, moving down the page, the court is then required to opine on a hypothetical situation and not a real controversy. This engages the doctrine of mootness, pursuant to which the court will decline to exercise its discretion to rule on moot questions. And very bottom of the page, last sentence, the jurisprudence of this court indicates that unnecessary constitutional pronouncement should be avoided. And we didn't highlight paragraph 13, but it's worth reviewing as well. The court comments on Borowski, and then it says, I cannot agree with my colleague that the fact that the case was fully argued in the Court of Appeal and this court is sufficient to warrant deciding difficult charter cases and laying down guidelines with respect to future public inquiries, simply because to do so might be helpful. It's not the function of this court to be helpful. This is not a reference. The function of this court is to decide real disputes that have real effects on the rights of individuals. The Bowen case at tab 25 picks up that theme. It's a decision of the Ontario Superior Court, again dealing with COVID-19 policies. And paragraph 28, the court deals with an argument that my friends have made here. I've also considered the applicant's submission that the court's opinion regarding the validity of the vaccination policy would be important and beneficial to the public, given the ongoing state of the COVID-19 pandemic and the likelihood that many organizations have or will have COVID-19 vaccination policies. The applicants urge me to allow the application to proceed. He says, I acknowledge there may be a public interest in the court's view. I accept that the policies are recent intervention and there is little case law on the point. However, I repeat my earlier comment that any opinion given by this court on the suspended termination provisions would be a hypothetical opinion. I find that there are several future scenarios that would render any hypothetical opinion ineffective or of little value. Specifically, I find that the suspended termination provisions may never be reinstated by the city, and therefore any decision today would be of no effect. Even if the city decided to reinstate termination provisions, the city may choose to do so using different wording or different conditions or different exemptions, changes to the vaccination policy itself. In those circumstances, any decision today on the current suspended provisions would be of no use to the public. And I heard Justice Coyette make that very point with my friend, Mr. Breswaros. Will circumstances be the same or will they change? The answer is undoubtedly circumstances will change. The nature of any restrictions will change, the science will change, the nature of a pandemic or any future challenge, whether it's a health challenge or a safety challenge or a security challenge. And the difficulty, the concern expressed by the court in Phillips is that there may be unforeseen circumstances in passing judgment that it's not necessary to pass judgment on. In the absence of a real dispute, the court should not be answering those questions, unless it's a reference where the legislature puts a question to the court to obtain that guidance. That's not what we have in this situation. I want to take you to the WorkSafe case, which is in the first volume. I'm sorry, I have the wrong tab. WorkSafe is in the second volume. Is it tab 40? Second to last. WorkSafe again dealt with COVID-19 restrictions on attending in closed quarters, put it that way. The legislation was repealed, and the court says at paragraph 5 that the repeal of the legislation is a classic example of mootness. They refer to the Supreme Court's decision in Wire and Huntington. Paragraph 6, any adverse effects caused by the impugned regulations on the lives and livelihoods of the applicant's members ended when those regulations were revoked and replaced. The issues raised by the application have become academic. And paragraph 7, I do not agree with counsel for the applicant that the possibility of new discriminatory regulations in the future keeps the issues alive. And we heard that argument this morning. The validity of any new regulation would have to be determined on the facts and circumstances at that time. And last sentence, quite the contrary, the COVID-19 crisis has led the government to revisit its response to the public health crisis on an ongoing basis as circumstances have changed. And the changes to regulations affecting establishments affected by the impugned regulations reflect this pattern. Again, the theme is changes will be made, circumstances will be changed, science will change, and all of that has to be taken into consideration. The Baber case is also relevant, and again, I didn't write down the tab number. It's tab 23, I'm sorry. Decision of the Ontario Court of Appeal dealing with the question of standing to challenge COVID-19 regulations. And paragraph 8, the court says, we conclude that the issue of Mr. Baber's private interest standing to bring the application is moot. Decision by this court on whether he has a private interest standing to bring this particular application would not resolve any controversy that affects his rights. This is so for two reasons. And the first is, if public health restrictions related to the pandemic are enacted in the future, and if Mr. Baber seeks to challenge them, his private interest standing to bring that hypothetical future application would be based on the circumstances and evidentiary record in that future application. The application judge's reasons would not be binding in a hypothetical future application. I won't take you to them, but we have two other decisions of this court, the NO case, which is 2016 FCA 214, and the Guzman case, 2007 FCA 358, both of which say, in response to arguments by the appellants, that the arguments they're making are too speculative to justify proceeding in the circumstances. And finally, perhaps we can go to the Laverne-Poitras case, another COVID-19 case, and it's at tab 30. Decision of the federal court. Paragraph 15 on page 8. With regard to Mr. Laverne-Poitras, and this case had to do with, as I recall, it was vaccination requirements for suppliers to the federal government. And paragraph 15, the court says, with regard to Mr. Laverne-Poitras' concerns regarding the potential reinstatement of the policy, I agree with the Attorney General that such concerns are speculative. Given that there's no longer a bar on his employment, the substratum of the underlying application is no longer present. With respect to his intent to seek financial compensation by way of an action, potential future litigation is insufficient, a live controversy. And then finally at 17, as there is no live controversy, the underlying application is moot. And so the theme through all of these cases is, it is not the function of this court to engage in deciding cases for the future. It is not the function of this court to be helpful, because in the absence of a necessary decision to decide cases that actually affect rights now, there is the potential that there will be interference for the future, or that there will be guidance which is not of assistance in future cases. And again, if we go to the Phillips case, tab 33, the court speaks at paragraph 9 that the policy of restraint is based on the realization that unnecessary constitutional pronouncements may prejudice future cases. the implications of which have not been foreseen. And that is the policy of restraint. So I submit that that was a policy which the applications judge, the motions judge in this case, respected completely, had in mind when she was reviewing the circumstances of this case. Now, a lot of arguments we heard this morning, let me try and address them in a more or less organized fashion. And perhaps building on the theme I've just mentioned, I spoke about Phillips and the constitutional prejudice that may arise. If the motions judge had decided this case on the merits, it would have engaged in a form of lawmaking that is reserved to legislatures. This court has so held in the Yahan case and in the McNally case. I have not included those, but they're in the major books of authorities. In Yahan, there was a resource project that was cancelled, and the court decided not to proceed with the consideration of the rights of the various Indigenous bands in the circumstances because they would be assessed in the abstract. And likewise, McNally, a tax case, the court said, absent a real dispute, the judicial pronouncement of legal principles can smack of gratuitous lawmaking, something which is reserved exclusively to the legislative branch. I have included in our compendium the QP case, and that is at tab 26. Another decision of Justice Stratus. There's a work refusal case, and it was determined in the circumstances that the matter was moot. And at paragraph 7, Justice Stratus says the party's only possible interest in the case continuing is jurisprudential. A mere jurisprudential interest fails to satisfy the need for a concrete and tangible controversy. Even the jurisprudential interest in this case may be moot. As will be explained, the legislation in this issue has changed. And the court, as I've said, at paragraph 13, talks about lawmaking for the sake of lawmaking. So the question might well be asked, so why not proceed in the circumstances of this case? The record has been set. It's a 14,000-page record, but it's set. The applications judge could have gone on to consider it. But there was no live controversy. There was no need to resolve the issues. Setting criteria that might affect how future pandemics are dealt with or other challenges to public security or safety or health may not be appropriate for those new circumstances. It is true that we can learn from decided cases. But we are always guided by the rationale of those decisions and the way in which the court decided to resolve the issues and to advance or not the rights of the parties. And if there is no reason to do so, then it's not appropriate for this court to decide it. And finally, I'll take you to the Pelche case on this point, which is another decision of this court in 2021. As was noted in that case, which was a challenge to public health bylaws created by a band council.
Which tab?
Sorry, tab 32. Decision of Justice Zinn of the federal court. These were bylaws created by a council. Paragraph 18. I concur with the observation of Justice McVeigh in Cheatham versus Fort McMurray at paragraph 41 that doing what Mr. Pelche asks would result in this court rendering a judgment that would intrude into the legislative sphere of a band council, when the court's role on judicial review is not to create general precedents to govern future interactions, but rather to scrutinize the actual decisions under review. And so I say, this is what Justice Gagne had in mind when at paragraph 50, she says, and let me find her, make sure I have it in front of me. It's tab 6 of the compendium. It's not the role of this court to dictate or prevent future government actions. That is what she's referring to. This line of authority, the proper role of the court. She understands it. She doesn't have to analyze it. She is a judge. She's aware of Phillips. She refers to Phillips in paragraph 28 in her decision. Any legal or constitutional pronouncement could prejudice future cases and should be avoided, citing Phillips. And she says in the sentence before that, it's well known the court should refrain from expressing opinions on question of law in a vacuum, or where it is unnecessary to dispose of a case. And that's the answer. We're not saying that there weren't facts on which this case should have been decided, could have been decided, but it's unnecessary to dispose of the case. Now, with respect to the fine balance of the Borowski factors, we say in our written submissions that there are 6 reasons why she got the balance right. I'll briefly touch on them without going into them in great detail. The first is the decision would have no practical effect on the appellants. And this goes to the second aspect of Borowski, the judicial economies, judicial resources. After the mandates were repealed, there was no concrete or tangible relief to be provided to the appellants. They have no continuing effect. And she dealt with this at paragraph 41 of the decision. The judge also noted that any declaration that the mandates were invalid or otherwise not compliant with the charter would not have any practical utility, paragraph 32. By contrast, there are cases where there may be some practical utility, and we referred to 3 of them in our materials, in our argument. I don't intend to take you through them, but I just note in passing, there is the Association des Parents case, 2015, Supreme Court of Canada, number 21, the paragraph 64 to 68, where the court says, a declaration might serve to encourage the parties to remedy ongoing breaches of minority language educational rights that were not before the court, but they may be of some assistance. Shaka, a 2019 decision of the federal court, 2019 FC 798, dealt with the pre-removal risk assessment in citizenship cases. And they said, a declaration may affect the ability of this individual to obtain refugee status. And likewise, the Ewart case, which one of my friends referred to as another decision of the Supreme Court, 2018 SCC 30, the court found that a declaration, notwithstanding the mootness, the declaration regarding the continued use of assessment tools for Indigenous inmates would directly affect decisions made about his incarceration. There was one other case in passing that our friends mentioned, a case called Corbière versus Houston, one of the cases that my friend Mr. Preswell has put before the court recently. It's a 1999 decision of this court, but you'll find if you review that case that the reason why the court decided it was not moot was because there was still an effort by the individual to clear his reputation, which has been tarnished by an incorrect decision. So although new band councils had taken place, new band elections had taken place. The live controversy of defending his reputation was the issue the court dealt with. None of that is an issue in this case. A decision would have no practical effect on the state of the law. There was no uncertain jurisprudence regarding Section 6.
What do you call the collateral consequences?
Collateral consequences, indeed, yes. I say there's no uncertain jurisprudence regarding charter standards. It's a question of applying the charter to the particular facts in this case. There's no jurisprudential value of having the court inquire into this in the absence of a concrete and tangible dispute. The court noted that the applications would have a significant draw on scarce judicial resources. She noted a 14,000-page record, 23 affidavits, 15 expert reports of more than 6,000 pages, extensive and highly technical evidence, 32 days of cross-examination on transcript. So there's going to be a 5-day hearing and then extensive preparation, consideration of the evidence, preparation of reasons. That's a lot of the court's time spent on this issue. I'll note in passing that my friends made reference to some of that record. I will not do so. It's not appropriate, I say, for this appeal to refer to that record. In any event, I say my friends have taken a highly selective reading of certain portions, and the job of the judge, respectfully, is to look at the entire record and make decisions. And so the fact that my friends choose to highlight certain sections does not mean that those are the most important sections or those should be given extra weight. Indeed, I would argue it's not the function of the application judge, the motion judge in this case, to read the entire record and make decisions as to what are the appropriate facts of the case. But it's to look at the issues in the case and to look at whether or not, in particular, rights are affected in the present day at the time she made her decision. Insofar as the argument is made that the air and rail passenger vaccination mandates were not evasive of review, she deals with that in her decision at paragraphs 43. She says public health measures were considered in other cases. These very measures were considered in the Metelo case in Quebec. Section 6 was not considered, but Section 7 certainly was. And the court said Section 6 is not an issue, but given the repeal, the proper way to challenge is via an action for damages. So if individuals believe that they have suffered real consequences as a result of these measures, then an action is the appropriate forum to raise those cases. I note in passing that quarantine measures, sorry.
Did you say the Metelo case was referred to by Justice?
I believe so, paragraph 43.
43 for me is
44. 44.
Thank you.
She does it in 44, 45, and then over at 46. And over at 46, she makes the statement I was just summarizing. It is true that none of these proceedings will test the IOs and MO against Section 6 of the Charter, but as indicated above, considering they are no longer in force, the proper vehicle will be an action in damages if the applicant suffered any damages as a result of these temporary measures. The court would then have the proper factual background to assess the applicant's charter rights. I point out, as I believe someone did this morning, that the Spencer case does deal with Section 6 as well in relation to quarantine measures. And a number of the cases point out that it would be speculative to suggest that future provisions will be evasive of review. I've already, in my discussion of speculative measures and the role of the court, addressed the argument that a decision would be of limited value in future cases. Circumstances will be different. I've taken you to Workspace and Baber. I won't repeat that. Finally, the important subject matter did not warrant hearing the moot applications. My friends say, well, there are interested, the Canadian public is interested in a resolution of these issues. But the measures that are no longer in effect cannot be said to continue to affect Canadians or amount to an issue of national importance. Even if they could, there must be some notion of the social cost of uncertainty in the law in leaving the matter undecided. And I say there is no such social cost here. I go further. Reference was made to public interest this morning, and it's important to remember what Borowski said about public interest at page 361. There also exists an ill-defined basis for justifying the deployment of judicial resources in cases which raise an issue of public importance of which a resolution is in the public interest. The economies of judicial involvement are weighed against the social cost of uncertainty of the law. And so the court is talking about not just social interest or jurisprudential interest, but is there uncertainty in the law that needs to be resolved? And in my submission, there is not. That uncertainty will not be resolved in deciding this case now. It will have to be decided on new facts in future cases. Mr. Presvelos made an argument about declarations and how they survive mootness. The cases in my submission are clear that mootness cannot be avoided on the basis that declaratory relief is sought. The authorities for that are the Fogel and Ramon cases, which are in footnote 80 of our Memorandum of Fact and Law. I won't take you there. I've spoken already about the Supreme Court decision in Phillips, about the importance of avoiding expressing an opinion on questions of law where it's not necessary to do so. And I'll take you to the Rebel News case, which is at tab 35. It was a request for accreditation with respect to a election proceeding, as I recall. And paragraph 64, by the way, it was a decision of Madam Justice Roussel of the Federal Court, 2020. Second sentence, it is not the role of this court to decide purely abstract and academic questions when there is no obvious useful purpose to be served by granting the declaratory relief. The Supreme Court has held that the court should avoid expressing an opinion on the question of law where it is not necessary to do so to dispose of a case, especially where the case is constitutional in nature. Talk about Phillips. In the circumstances of this case, the administrative law remedies, this paragraph 64, were in effect granted by Justice Zinn, and there is no need for a judge on the merits to decide the constitutional issue. Finally, on this point, we have the right to life case, which is at tab 36. Decision of this court, Justice Monahan. Paragraph 13, a declaration may be granted only if it will have practical utility. That is, if it will settle a live controversy between the parties. And again, I suggest that is informed by this notion of a judicial reluctance to weigh in on constitutional issues where it's unnecessary to do so. And again, paragraph 14, the court says, if in the future a funding program contains similar requirement, it can be challenged at that time. And the challenge would depend upon the circumstances. There's a good chance the decision in this case would be of no use in that later case. And finally, we have the Met case at tab 28. Paragraph 6, decision of Justice Dawson of this court. The need for a live controversy is set out yet again. So, what Mr. Presvelos is looking for, amongst others, is guidance with respect to the future. something to assist those who feel aggrieved by these measures with some solace, some understanding, some appreciation of the risks, of the issues and the rights involved, and some guidance with respect to the future. And again, I say that's not the role of this court on an appeal of this nature. A few other points I wanted to raise that my friends spoke to. In paragraph 66, we deal with the point that I've just been making. We agree there may be circumstances where a declaration may be useful beyond determining some immediate dispute, but the authorities, and I've taken you to these ones already, again demonstrate that the declarations have to have some practical utility. So even if the underlying dispute is gone, the direct declaration still has to have practical utility. And I've discussed those cases already, so I won't repeat them. I simply remind the court that my friends have suggested the BC Court of Appeal has rendered decision on arguments that appeals in those cases are moot. We don't know what the court said. We don't know what the reasoning is, what the rationale is. Those were, as I understand it, in any event, appeals from decisions of the Superior Court that dealt with the cases on their merits. So perhaps the court has some interest in looking at whether or not the court got that right. Again, that is not this case. This is a case where the court refused to consider the merits. I want to remind the court as well that in appreciating whether or not Justice Gagné has committed a palpable and overriding error, it's instructive to look at her decision as a whole and not just selective portions. You can't take a line, you can't engage in a line-by-line reading and say, well, she didn't do enough or didn't provide enough analysis or did not consider all the factors or didn't weigh them properly. So long as she adverted to them and discussed them, then you can look at the decision as a whole and infer from her entire decision that she has addressed those matters properly. Certainly, there is nothing in her decision, in my submission, that would constitute a palpable and overriding error, in the sense that she got the facts wrong or didn't apply the criteria properly. She found that there was an adversarial interest. And I'm afraid I don't understand my friend's point about, well, other circumstances, the threat of reimposition increases the adversarial interest. The adversarial interest criterion factor is simply concerned with whether or not there are two parties well-informed, trained in the law, who can argue the issues before the court fully and fairly. It has nothing to do with threats of reimposition, anything of that nature. She certainly conceded, we conceded there was an adversarial interest. Judicial economy, she discussed it at length, and I've taken you through our response to that. And I say again on paragraphs 28 and 40, she clearly understood her role, the court's role, on judicial review. In my submission, there's no basis for this court not to follow the decisions of this court in Spencer and Waddington and Plato, and not to weigh in and rebalance the factors in the absence of a palpable and overriding error. And I'll say finally that mootness applies equally to not only the constitutional arguments, but the virus arguments and the Election Act arguments. None of those are an issue. Question of virus, the question of whether or not it's an appropriate order under the Aeronautics Act, falls to be decided according to the facts at the time. What's the nature of the threat? Is it a genuine aviation threat to aviation or not? That can only be decided on the facts at the time it is reimposed, if it's going to be reimposed. And so I say for those reasons, those questions are moot as well. Just to comment on some of the cases where the courts did proceed. We have the Metalo case, which we deal with at paragraphs 76 and 78 of our factum. What happened in that case was that the repeal of the measures occurred between the hearing and the issuance of reasons. So given the fact that the case had been argued, that there were other related disputes involving the plaintiffs' union members and employers, and a clear desire of all parties to have a judgment, the Quebec Superior Court exercised its discretion to deliver a ruling. This case is different. There has been no argument on the appeal, on the merits. The Gateway Bible Church case, to which my friend referred to, a 2023 decision of the Manitoba Court of Appeal. It's important to say that, again, the case was fully argued. And on the judicial economy point, the court said the parties fully litigated the matter before the applications judge at a time when those orders were in effect, when there were orders in effect similar to those challenged. The court says there were also special circumstances, but doesn't explain what those are. And then said, with respect to unnecessary constitutional pronouncements, well, other courts have looked at this. Deciding again a matter in the absence of live controversy would be making law where it's unnecessary to dispose of a case. And so I say Gateway can be distinguished. Corbière was spoken about again. There was the issue of representation. The Cassian case, another case from the BC Supreme Court dealing with a vaccine passport regime. It's 2022 BCSC 1603. It was alleged that the medical exemption regime discriminates against persons with disabilities. Mootness is dealt with the paragraphs 111 to 114. And the court said the difficulty with the respondent's submission is that they could offer no assurance that the impugned aspects of the order would not be reintroduced. That's not this case. They've been repealed now for 15 months, 3 months at the time the case was decided. The difficulty with this judgment is that's not the test for mootness. The test is whether there was a live controversy at the time. And there appears to be no consideration of the discretionary factors in Borowski. For continuing. Likewise, the Canadian Society for Advancement of Science 2022 BCSC 1606. Restrictions were removed in April. Case was argued in May. Mootness is dealt with in paragraphs 67 to 70. Again, the same statement. No assurance they would not be reintroduced. In this case, the court only said there was an adversarial context. Nothing about the other aspects of the case, judicial economy, or the role of the courts. So if we're talking about a case where a judge has not considered all the factors, that's a good example of the court failing to do so. So if that's now been appealed and BC Court of Appeal has decided to weigh in, we don't know why, we don't know what the circumstances are, and I respectfully submit that we can't have regard for those Court of Appeal decisions. Check with my friends. Thank you. Oh, with respect to the issue of costs, I have nothing else on the merits, unless you have any questions. No, thank you. On the issue of costs, we did a quick calculation on the Category 3. It works out to single counsel with respect. Single counsel, it works out to something like $3,000. My submission is, given the the need to respond to 4 separate sets of arguments, prepare fully, and with the assistance of my colleagues here, second counsel, I would submit that an amount more in the neighborhood of $5,000 would be appropriate.
Very good. Thank you.
Thank you.
Now, I'm conscious that the appellants typically would have a right of reply, and I certainly want to hear on cost. But I'm also conscious the appellants pretty much used up all their time and then some. That said, I'm prepared to allow a very short time for reply from whoever for the appellants would like to reply.
5 minutes indulgence, I promise I'll be no more. Good afternoon again. I just wish to clarify some of the points that were addressed by my friend, and in doing so, certainly not re-argue the points that were addressed, but as I stated, to provide some clarification in light of statements made. The first aspect that I'd like to clarify is the sentiment of Associate Chief Justice Gagné at paragraphs 28 and paragraphs 50 of the decision. The statement at paragraph 28 has a very different line of inquiry and aim than the third factor of the Borowski mootness analysis. What is being contemplated is the inquiry as to whether there is a live controversy, and that is the context in which the statement is made. The discussion between ascertaining whether there's a live controversy and the analysis to undertake with respect to flexibility is different. One is a theory for not hearing a matter that has become moot, but the other one considers if we decide to hear the matter anyways, would we be overstepping the judicial boundaries in this case? So this is a conditional analysis, not an interchangeable analysis. The fact that there is a general sentiment that the courts do not make constitutional pronouncements speaks to the live controversy. It cannot be conflated and understood and inferred as also speaking to a secondary consideration, which necessarily does not arise in the first instance.
Well, I understand that there are different issues, but I think you're asking us to accept that she considered it for the purposes of the first step and then forgot about it for the purposes of the second step.
No, Your Honor, what I'm asking this court to take notice of is that Associate Chief Justice Gagné correctly identified the principle. The principle applies when the court has concern as to whether or not there is a live controversy. And that comment is in reference to the fact that ordinarily a court is not going to decide an active matter. A court is not going to decide a matter that is not actively before it. That is a different sentiment than saying if we decide to hear this matter, notwithstanding there's no live controversy, is the thing we're being asked to do within the scope of our judicial authority. They're conceptually very different things. And this is why I'm saying it's conditional logic. It's not interchangeable logic. And at paragraph 50, with respect to declarations of constitutionality, there is a missing word, and that missing word is unnecessarily. The reality is judicial decisions do set the boundaries of government actions and is not infrequent within which courts do prevent government actions in certain circumstances. The next quick point is my friend's reference to Phillips versus Nova Scotia. The interesting part about Phillips versus Nova Scotia, it actually bears some factual resemblance to the Borowski case, because in that situation, there was a change in the circumstance. And the party in that situation also sought to change the scope of relief in a material way. And it is for that reason at paragraph 12 that the court says, the court, however, declined to deal with the issue of fetal rights under Section 7. That follows after the court says, the court felt constrained to deal with the legal issues with respect to the propriety of granting an injunction in the circumstances. In other words, what had happened in that case, which is factually, I would say, more similar to Borowski, is there's a change in the individual person's circumstances with respect to the injunction, and then they wanted to shift what it was that they were asking the court to consider to make a larger declaration on fetal rights. This is not analogous to the type of relief we're seeking. I would also disagree that on an appeal, it is appropriate to engage in inquiry with respect to what the judge had in mind in reference to cases in my friend's factum. In fact, I would say that this underscores the reason why we need reasons in order to eliminate such guesswork. And finally, with respect to the public interest, there is a very important sentiment that is expressed by the Supreme Court in the overview of this decision, and it is as follows. I would add that more than a cogent generalization is probably undesirable because an exhaustive list would unduly fetter the court's discretion in future cases. It is, however, a discretion to be judicially exercised with due regard for the established principles. A one-dimensional consideration of the public interest factor would contradict the spirit and approach of the Borowski factors. Those are my replies, and I appreciate your time. Thank you.
Thank you. Do any of the appellants have anything to say about the costs request from the respondent? Does the amount sound reasonable? I would take it that, regardless of which direction we go, I guess the number 5,000 is on the table.
Yes, Justice Locke, in terms of the question of costs, I mean, we haven't had a chance to put together a factum or brief or provide case law to the court on that issue. I can say that, as you know, I argued the Gateway Bible case in Manitoba, and the government there was asking for a considerable amount of costs as we were unsuccessful in the litigation. And Chief Justice Joyal of the Manitoba Court of Queen's Bench at the time found that, and he agreed with us, that case was precedent setting in Manitoba. The issues were of great significance to all Manitobans, and he declined to order any cost award against the applicants in that case due to the resounding public interest. I would say in this case is historic as well. It is precedent. It ought to be precedent setting. If you decide to send it back down, and we would submit that similarly to the Manitoba Gateway Bible case issue, a decision on costs, which I'm happy to provide the court should you request it, that there ought not to be a cost award against any of the appellants due to the public interest nature of this case.
Am I right that there were no costs at the federal court level? I don't see, I'm looking at the judgment, I don't see costs there.
There was a separate costs award made.
Oh, submissions on, right, okay. And, okay.
Cost for $10,000.
Okay, thank you very much.
Thank you.
Oui.
Monsieur le juge, pas sur le fond, c'est pas une réplique sur le fond, c'est sur la question des coûts.
Oui.
Je voulais simplement rappeler que ce qui me distingue dans cette instance, c'est que derrière la touche d'avocat, il y a un défendeur qui se représente seul, et que je pense que toute la question de l'accessibilité de la justice se pose. J'ai témoigné des coûts que m'a coûté de porter cette cause depuis le tout début. Et de mémoire, là, selon Statistique Canada, on est à environ 50 000 $ de salaire moyen d'un Canadien, et qu'un coût de 5 000 $ représenterait donc 10% d'un salaire annuel. Je pense que la question de l'accessibilité de la justice se pose sur ce point, et je suis confiant que la Cour saura en tenir compte. Merci.
Merci. Thank you. It's been an interesting morning. We're going to take the decision under reserve, and I'm sure the parties are eager to get a decision, so we'll do what we can to try and get it out the door as quickly as possible. I am conscious that we'll have to have it translated before it's issued under the Official Languages Act. This is a case that will have to be, we'll have to release our decision in both languages at the same time. Thank you.
Order. Alors.